Yep, we can hear you
Yep,
loud and
I
clear.
can I can hear you.
All right. Welcome, everybody. Today, we're going to talk a little bit about legal issues with COVID and VR. It's a pleasure to come back again. We've spoken to this conference before. I want to thank Jeremy for inviting us back. Just briefly, I want to do a quick overview of who's speaking here today. My name is Jim Gatto, and I am a partner at Sheppard Mullin. I head up our games team and do a lot of work in the interactive entertainment space, including AR, VR, and related areas. The two partners that will be speaking, John Stoller nationally heads up our labor and employment practice, and he's going to talk today about a number of the employee-related issues as a result of COVID. And the other speaker will be Jay Ramsey. Oops, went backwards. And Jay is one of our business litigators, and he's going to talk about some of the business issues and some of the litigation-related issues, insurance, et cetera, with respect to COVID. Just briefly, the firm, some of you probably know us, we do work with a number of VR companies. We have 15 offices around the world, 900 plus lawyers, and cover a lot of areas from entertainment, games, technology, and traditional business and technology transactions. Do a lot of work in the games AR VR space. Today we're going to, normally we would cover a lot of what I'd call the traditional legal issues with VR. We've covered a lot of things in the past on licensing and IP protection, IP infringement, and some of these other topics. But today we're really going to focus on COVID, which was what Jeremy had requested, and based on some feedback that people had provided as far as what they wanted to see in the conference today. So we're going to cover that. Before I turn it over to John and Jay, just want to kind of set the stage a little bit. So, since the very beginning of the COVID outbreak, we really developed kind of a multidisciplinary task force to focus on really the full range of legal issues related to COVID. And there's a lot of them. We're not going to be able to cover all the issues today. But what I have up here is a page. You can go to our website. If you have any questions at all about COVID, we have a tremendous amount of resources that are designed to be client-friendly, to provide information on different topics. And if what you need is not answered there, feel free to reach out to one of us, and we'd be happy to follow up and talk to you. One of the things in particular I wanted to mention, and this kind of falls into John's area, we really developed a very extensive employer's guide to COVID. It's about almost a 700-page downloadable free guide that covers a lot of the legal issues. Oops, the slides keep jumping, I apologize. A lot of the legal issues with employees and COVID, and there's also this paycheck protection, the PPP workbook. So there's a lot of people have a lot of questions about PPE and loan forgiveness and everything else. There's a workbook there that provides a lot of the basic information you need. Again, it's a very useful tool. If there's additional questions, we have people that can help answer those questions. So with that, just as a kind of a brief intro, I want to turn it over now to John. And John's going to cover some of the employee issues with COVID and VR. And the one thing I'll just mention is that I know that a lot of there's both for like LBE, where you actually have in-person employees that are actually on the ground with customers. There's a set of issues, and for many companies in the ecosystem who have kind of still have offices and kind of corporate facilities, some of the issues will kind of transcend both scenarios, but John will touch on some of the issues that are specific to each. So with that, let me turn it over to John.
Thanks, Jim. Thanks all of you for having us present at this conference. It's my first time presenting virtually like this, and it's quite exciting. So I'm glad to see so many people here. And again, thanks for the invite. As Jim said, I lead our firm's global labor and employment practice, obviously as it relates to the COVID-19 and pandemic issues. For us labor lawyers, it's like drinking out of a fire hose because of so many new developments, both from a regulatory perspective and a practical perspective that we're seeing in our day-to-day work. This pandemic has certainly ushered in a completely new working dynamic, whether you're working remotely, whether you're working on site or at a particular client location. With respect to remote working, most companies across the country have required it. Employees have gotten used to it. Many employees will be continuing to work remotely due to health concerns or childcare issues, other obligations, and many more employees simply, and quite frankly, companies simply prefer it, that remote working environment. But now that many employers and businesses are reopening or engaging those efforts to reopen, as you might imagine, there are a host of issues, potential risks, both business risks, litigation risks, and a lot of planning, of course, relating to all that we need to consider as we move forward. And what I'm going to talk about for the next few minutes is some of those action plans or those items in an action plan that your organization should think about, regardless of how large or small you are, regardless of whether you have most of your workforce working in a traditional office environment or whether you're working on site at a particular client location or some other retail location, for example. The first thing is we want to have somebody in charge of the action plan, someone who is going to be responsible for administering procedures and protocols, answering questions that we might have from people that are working under our roof or working within the organization. It doesn't have to be somebody in HR. It doesn't have to be the most senior person in management, but certainly somebody that has the expertise and authority to make sure that our plan is being adhered to again, answer questions and be able to navigate and be flexible with respect to protocols as we learn more and more, not only about the pandemic issues and the remediation efforts, but how we can adapt our organization to deal with what is coming down the pike. One of the core hallmarks of any action plan, and a phrase that we are all too familiar with, is the concept of social distancing. Obviously, we want to make sure that any plan we have in place, that we communicate to our employees, regardless of where they work, the importance of social distancing, keeping that 6-foot distance where possible, making sure that we have some type of flexibility with respect to working hours or staggered shifts, if we can do that. To the extent that you are working in an office environment or overseeing an office environment, allowing the continued use of teleworking, allowing people to continue to work from home to the extent that is new to your organization. Whether we can increase the physical workspace within the office environment, as well as increasing the physical space between on-site locations as it relates to vendors and customers and VR users. As we're going to see in a minute, by virtue of this particular industry and the VR equipment that's typically used, there are a lot of things that come into play in terms of sanitizing and maintaining social distance protocols, which make it difficult to maintain those traditional protocols that we've heard about, particularly maintaining that 6-foot distance. Personal hygiene. Again, these are concepts that we all know too well at this point in time, but following and making sure we have CDC blessed or issued protocols with respect to personal hygiene, regarding hand washing, making sure we're using hand sanitizers with at least 60% alcohol content, having established protocols in effect, whether you're working in an office and we're talking about telephones that are used by groups of people, or copy machines or other office equipment, or whether we're talking about on-site locations and VR headsets, other types of VR equipment, both before and after it's used. In that connection, There was a recent press release put out by the Academy of International Extended Reality, which talked about the very concept of protocols and guidelines with respect to the safety of users who wear head-mounted displays and the use of immersive haptic devices. That has compelled the Academy here to provide basic guidelines that are very similar to what you see on the screen, essentially following the advice of the World Health Organization and the CDC to ensure that VR locations that have an entertainment component where customers are using those headsets, whether there's a use of immersive devices or other content showcasing at large gatherings, that those are all covered by protocols such as rigorous hand cleaning procedures. The idea that foam inserts on devices are not sufficient to enable effective cleaning of headsets. Making sure that our employees who are using this type of equipment, making sure they're trained on not only how to properly clean a headset, but to spot the signs of someone that looks as though they may have a high temperature or shortness of breath. Making sure our staff is trained to reconsider whether it's a good idea for them to be using these devices. Of course, making sure that every organization is providing the folks that work for us with adequate PPE materials, whether that is face masks, whether that is making sure that if they are working in an office environment, that perhaps we may have some other pieces of equipment that ensure their safety, whether it's plastic partitions, things of that nature, but making sure not only that we're providing this equipment, but that it's equipment that is effective to use. So when we talk about surgical masks, where we can get N95 respirators, we want to try to get those, not the ones that we're pulling out of a vending machine for 50 cents. It is incredibly important that we make sure, to the extent we can, monitor our employees, or at least keep our employees made aware of the testing and monitoring protocols that the CDC and the EEOC, the Equal Employment Opportunity Commission, has asked employers to have in place. Temperature testing is allowed in the workplace. We see temperature tests being taken not only in office lobbies, but also when you enter most locations that the public is now entering, whether it's stores, whether it's entertainment sites, etc. We also need to make sure that we have an appropriate, that we're able to identify and respond to exposure or infection events. Again, we're all well aware at this point as to the symptoms that emanate from COVID-19, but whether you're in the office environment or whether we have our own salespeople or folks that are working with the public in VR environments, identifying fevers and coughs and shortness of breath, identifying situations where we may not want to put our employees or the public in a potentially compromising situation. It's also important that you have policies or directives in place which tell employees what to do if they are exposed, if they believe they're exposed, or if they in fact report that they've been infected by COVID-19. Things like reminding the employee to identify any persons within the workplace that they had contact with within the prior 14 days. Letting employees know of our expectations regarding isolation and quarantine protocols. To the extent that employees are able to continue working from home, communicating to them what the telework expectations are if they are available to work. There are also various benefits under the Families First Act, which is benefits that are provided, leave of absence benefits that are provided for individuals that are facing COVID-19 symptoms, or if they have loved ones that they need to stay home for, to care for. We need to make sure that we're aware of those policies and those statutory obligations, and that we communicate them as well. Now, if the company does believe that someone is infected, or even if the company has reason to believe that somebody might be infected because they came into close contact with somebody who we know has had COVID-19, the company is allowed to direct that employee to leave the workplace. That's important to know. And you can require that employee stay out of the workplace, whether it's in the office, whether it's on site at a client site or some other outside location. You can to remain at home, or remain quarantined, or at least stay out of the work environment until they provide some type of medical clearance or medical documentation which makes clear that they have been retested and do not have the virus, or provide us some other assurance that they do not pose a threat to the employment ranks or to the general public. Again, when there is a situation of a COVID-19 event, either an infection or suspected infection, it's good practice to have some communications ready to be sent out, both to the existing workforce and to the potential consumers that you might be servicing. Having something prepared in advance obviously will be important, because we want to get that message out quickly, and we don't want to wait to have something drafted, have it reviewed and revised. Obviously, we need to move very quickly with respect to those types of communications, and we should be able to get those messages out as quickly as we can. There are also government reporting obligations, so you should keep that in mind. If there is a COVID-19 event, either in your office or off-site at another location where we have our employees working, there are OSHA reporting obligations. There are OSHA reporting obligations, which is the federal Occupational Safety and Health Administration's obligations, as well as local OSHA obligations. So depending on what state or states that you are doing business in, you may have local reporting obligations to make as well. If you have any questions, obviously you can ask that to either after this session or at some other time when you have those questions at the ready. I want to switch over now to policies that we have in place. Many organizations, hopefully all of you that have employees, have some type of employee handbook in place, which lays out various policies regarding how to conduct themselves in the workplace. The policies that we've seen implicated more frequently than others include teleworking, expense reimbursement, sick leave policies, travel policies, mental health policies. With respect to teleworking policies, we want to make sure that those policies do a couple of important things. Of course, we want to make sure people comply and understand the teleworking policies, that performance expectations are still going to be held to the same level. We have those same expectations of people performing their jobs as best as possible, even though they are teleworking and not performing them on site. We want to make sure that people are recording their hours of work, particularly as it relates to any employees that we have who may be paid on an hourly basis. We want to make sure that with respect to equipment that employees need, that they have the equipment that they need to perform their work. And we also want to make sure that employers are being careful with respect to cybersecurity issues, that if they are working remotely, that they are conducting work on our own systems or through their own servers, not their own personal email or personal electronic communications. We want them to use the company communications, which hopefully have proper protocols, safety protocols in place. With respect to expense reimbursement, the key things to take away there is that, and I've seen this a lot, when it comes to equipment and office equipment, or printer paper, printer cartridges, things of that nature that can get expensive. A lot of employees are buying this on their own and they're seeking reimbursement from the company. Many companies that have some type of system in place can get these types of these pieces of office equipment at obviously a much cheaper price and have it delivered to the employee. So we want to make sure that there's a way to monitor the expense reimbursement system and make sure that employees aren't abusing that. With respect to travel policies, we want to make sure that employees understand that there will be some limitations on discretionary travel, that there may be limitations on particular areas that we want them to travel to, that if they do travel to a hotspot, there might be quarantine protocols that they may need to follow. We want to make sure that employees that type of policy talks about PPE rather, personal protective equipment expectations, that they always wear a mask when they're traveling on an airline, for example, or when they're in a hotel. We want to make sure that we also have procedures in place regarding any concerns that employees have about traveling that might be required. If employees refuse to travel because they're concerned about their safety, having that dialogue in place to come up with a solution to that concern. With respect to just a quick word on leave of absence policies and mental health policies, again, just keep in mind that there are policies like the Family Medical Leave Act, which has existed well prior to the current pandemic, which allows employees to take leaves of absence for their own serious health condition of up to 12 weeks unpaid leave. And then now there are new statutes that relate to that provide leaves for employees relating to the coronavirus and the need for an employee to take time off to care for themselves because of a COVID-19 infection for themselves, but also due to perhaps a family member. Finally, a quick note on mental health policies. We're seeing many more employers put those types of policies in place, which talk about things like altering break schedules and work schedules if it's needed, creating quiet spaces in the office if the employee has been permitted to return to the workplace and is asked to return but is concerned about a more easy entrance back into the workforce, providing some softer way for them to come back. Having devices in place that create a quiet work environment, and of course even back to telecommuting, allowing people flexible work schedules to help ease them back into the work environment. People are still concerned with coming back to the office environment, and we need to be sensitive to that as we move forward. I want to also touch on some what I call post-pandemic litigation issues that we have seen and we're starting to see more and more of as it relates to things like employment discrimination cases, whistleblower and retaliation cases, wage and hour concerns. The WARN Act refers to the Workers Adjustment Retraining Notification Act, and that deals with situations where we are laying off large groups of employees. Depending on what state you're in, the threshold numbers vary, but generally speaking, if you're laying off, for example, in New York City, where I'm based out of, more than 25 employees, and that number affects more than 33% of your workforce, you might have an obligation to provide advance notice of that employment termination, up to 60 days in some cases. And if you can't provide that advance notice, then there may be a requirement to pay employees in lieu of notice. Now, there are exceptions to this, particularly an exception referred to as the unforeseen business circumstance, and a lot of employers have been faced with larger layoffs have been able to take advantage, or at least are trying to take advantage of that exception, given the fact that this pandemic was certainly something that was unexpected. With respect to furloughs and layoffs, I think a lot of organizations have seen certainly one or the other, or perhaps both. Many employers, particularly who have on-site locations via VR locations outside of a typical office environment have not been able to run those facilities for obvious reasons. And I think most employers have tried to do the right thing in not laying people off, not terminating them, but furloughing them. Basically saying, we're going to basically temporarily lay you off or furlough you. In some cases, you can still pay employees while they're on furlough or pay them at a reduced salary. Some employers are not able to pay employees at all. After groups of employees have been furloughed, a lot of companies now, as we sit here today, are coming to the realization that they can't bring these people back or can't bring as many of those people furloughed as they want to back into the workforce. So they're forced to terminate them. And when that happens, we're seeing employees challenge those decisions. Why were they selected for a layoff as opposed to perhaps another employee? Do you have a female employee who was kept, but her male counterpart was not? Does that male employee now have a gender discrimination case? You have an Asian employee that was kept, but an African American employee in the same type of position was not. Are we now facing, do we need to be concerned about a race discrimination case? So we want to make sure that when we're making these decisions, we're making them based on legitimate business reasons. Other litigation risks that you should be aware of relate to employees with medical conditions. And something that might be of interest to hear, since there's one reputable source out there that has stated that since the COVID-19 pandemic really took shape, there's been upwards of 500 lawsuits filed by employees alleging some type of employment discrimination claim. The most common of those claims involve requests to work remotely because of a medical condition. In fact, upwards of 125 of those 500 cases dealt with claims of that type, and that's really presented a balancing act for employers. The idea of being able to work from home or return to the office. The employees with medical conditions are entitled to what's known as reasonable accommodations under the Americans with Disabilities Act. Employers in some situations are required to allow employees to continue to work from home if they have a medical condition that qualifies as a disability under the ADA. But the accommodation still has to be a reasonable accommodation. And if the employee cannot perform the essential functions of their job, or if it would be an undue hardship on the employer to allow that employee to continue to work from home, then there arguably is not a requirement that we allow that employee to continue working from home. So if you have someone who's working for you that is required to work off-site, or that is required to help a consumer, put on a VR device or be able to work with the public, that is the essential functions of their job. Allowing them to work from home would certainly be an argument for an undue hardship, and that's a situation where we might want to revisit, and we may be forced to deny that employee the accommodation request. So again, the point I'm trying to make here is that these are very nuanced situations, very fact-specific situations, the ones that you should speak to your legal advisor with or your HR professional with if and when you are faced with those decisions. I also want to talk about wage and hour issues for just a bit. Wage and hour issues are really a huge litigation risk to employers in the COVID-19 era. As hopefully most of you know, with limited exceptions, employees who are exempt, that is, employees who are not entitled to overtime, salaried employees, they need to receive their full salary in any week in which they are performing any type of work, regardless of the location that they are working in. By the same token, it's very critical for non-exempt employees who are paid on an hourly basis, to record all of their time. We need to ensure that those employees are recording all of their time and that we are capturing that. Employers can certainly implement policies to control the amount of time worked and to ensure that we are recording it properly. In the absence of that, you could potentially be faced with claims for unpaid overtime or off the clock work. Employees claiming that they were directed to work and we're not paid for that work. So we need to make sure that we're monitoring that as best as we possibly can. So last thing I want to cover here is the idea that, sorry, just about to turn it over to Jay. The last thing I want to cover here is a question that we're hearing come up quite a bit, and that is the idea that employers are now requiring employees in some places to return to work, to return to the working environment, whether it's to the office, whether it's to some on-site location. And what do we do about employees who claim that workplace, whether it's again in the office or somewhere else? What if we do if they claim that the workplace isn't safe? Well, there are two federal laws that should be considered. One is the OSHA Act, the Occupational Safety and Health Act that I referenced earlier, and the other is the National Labor Relations Act. Per OSHA guidance, an employee can only refuse an assignment, a work assignment, if it places them in, quote, imminent danger of death or serious physical harm. That's a very, very high standard to satisfy. And no court, no administrative panel has yet ruled that the mere existence of COVID-19 meets this standard or presents that imminent danger. So as a general matter, if employers are strictly complying with all of the protocols that I laid out at the beginning of my discussion here, having those types of action plans in place, complying with CDC guidance regarding a safe workplace and provision of PPE and sanitizing things, employees are very unlikely to have a legitimate basis to refuse to return to work or assert some type of whistleblower claim or retaliation claim under employment law statutes. That is what I'm going to cover in this section. I'm now going to turn it over to Jay. I hope you found this informative. And again, I'm sure there's some way to contact us either through this conference or later on if you have any. Jay?
Great, thank you. Sorry, I'll step forward so I can see. Thanks for having us. This is a first for me and fascinating. I discovered I can walk through walls in the environment last night, so you should all go try it afterwards. So I am covering a range of different issues that we are seeing clients in your and similar spaces having to address as a result of COVID. Some of it is bleeding into other things that have already been going on or are always concerns, but they may be more heightened at this time, and especially as we start going back to work and reopening and so forth. So I will, no, sorry. There we go. Uh-oh. Okay. So the first is opening back up. So our spaces where folks come in, put on the VR equipment and play and engage in their game. It's going to depend on jurisdiction whether or not and when these types of spaces can and will open up. So that is hard to advise on, but it does change often rapidly and changes by jurisdiction. One thing we can definitely say, though, is that when we're able to go back, there will be certain things that the company will want to do to try and limit their exposure and ensure the safety of their customers. And a lot of this is what John was already talking about with employees. So this is PPE, masks, social distancing, making sure spaces are cleaned and so on and so forth. So I won't cover a lot of that. But one thing that I would add that is helpful is in an environment like this, you should be able, we would suggest that you set up, if you don't already have, a system where people are making appointments so that you limit the amount of interaction and in and out of people at the same time. So for example, just a couple of weeks ago, I finally got my haircut for the first time, and the way that worked, a barbershop, was they were staggering appointments so people weren't coming in and out at the same time, and then also obviously limiting the number of people they had. So that's an example of something that you might consider doing. Another one is we've seen some companies think about contact tracing and protocols around that. So if they find out that someone at the facility ended up with COVID, they may be able to notify others. There's no requirement about this, at least as of yet. But there are, if you are tracking who's coming and when, you may have information that can help with that. And that may be something to consider putting into place a system in advance so that if you get into a situation like that, you can respond. The one point about all of this, though, is we do need to be careful. There, in this space, and also in COVID times, especially when we're talking about health data and information, there are a number of privacy laws that can apply that will limit what you can gather, how you can store it, how you can share it, whether you can share it, and any number of things. And there are progressively more and more states and other even federal laws that getting enacted that touch on privacy and companies' requirements to protect that data. It's one of the fastest growing areas in litigation generally, especially for sort of retail and customer facing or consumer facing companies where you're dealing with consumers and have their data. And this can be anything. It can be name and address. You may have folks signing up with credit card information. Some places, if you, to the extent you're taking temperature checks on the walk-in, I know there is some technology around monitoring heart rates and tracking eye movement and maybe other physiological responses. And so if anything like that is being done and stored, you need to be careful with how you're managing that data and making sure it stays safe and also, frankly, getting consent from the individual. So there's a lot of laws around that could take up an hour of conversation, but I wanted to flag that as an issue to really think about. Anytime you're getting information from a person, make sure you have consent to get it, and then know what tell them what you're using it for. These are the basics, and then making sure you're storing it safely so that it doesn't get out. So another thing, sorry, jumped ahead there. Another thing we've seen some companies considering, I've even talked to a set of just traditional movie houses thinking about trying to implement liability waivers. So for customers who come in, and this would be, you're coming to our facility, you understand that there's a pandemic right now, that COVID-19 is very contagious, that you will be around a number of people, so on and so forth. And basically, you are, by entering this facility, you may be increasing your risk to get the disease, and so we are asking you to sign this document that says you're waiving any risks associated with that. Unclear right now whether any of those liability waivers would be enforceable. Probably not, especially if the company is not taking sufficient procedures, cleaning, social distancing, masks, and so on and so forth. So it is not something that is a silver bullet that will get you out of everything. We've also seen some retail locations put up signs at the entrance or maybe throughout the store that basically says the same thing, that by being in here, you're increasing your risk of contracting the virus, and that you're assuming the risk of doing so. Again, these things, they may be helpful, but it is unclear whether they'd ever be enforceable. And so I don't want you to think that you could put something like this up and then not worry at all about maintaining proper procedures and cleaning and social distancing and so forth. The other side of this is you do want to be careful when you're making any promises or statements about what you're doing. So you certainly don't want to say this is a COVID-free zone when you obviously cannot prove that or ever establish that. But anytime you're making a representation to a customer that's coming in about what you're doing, you need to make sure that you're doing it. I know that sounds simple, but that is an area that can open folks up to liability should someone contract the virus on the location. One footnote on all of this is it is going to be very difficult for anyone to ever prove that they got the virus at your location. But that does not mean you won't get sued or won't have to incur legal fees fending off an issue like that. Okay, so switching topics, another issue we're seeing a lot is lease agreements. We're a ways into the shutdown, obviously, at this point, and so some of these issues have calmed down, but I wanted to touch on it briefly. And this goes for people who are leasing space and also for the landlords. But in each case, the basic advice of how to deal with these situations where the location is shut down, it can't be used, what rent has to be paid, how do we deal with this situation? And so that's all something you should definitely talk to your legal advisors about if you're in a situation where you need to get out of a lease or enforce a lease or something like that. But the key provisions tend to be around the termination provisions on the lease, what would entitle someone to terminate the lease, and also provisions around rent reduction or basically extending the lease for a reduction in rent abatement in the interim period. So that's something to look at. And also, now as we're coming back, if we're thinking about entering into new leases or new agreements or amendments, the key is to be as specific as you can about what to do in a situation like this pandemic. I mean, it's impossible to predict what's going to come next, but we at least know about the pandemic now and can do our best to draft provisions that are very clear about what happens if a situation arises again where the world shuts down. Similarly, if you are in frankly, any type of agreement with any vendor where you're sharing a space with other people. So for example, the operator of a movie chain, for example, may not actually operate the food and beverage that's available at the theater. And so there's going to be an agreement between the movie operator and the food vendor. That's just an example. But you can see where anytime there's more than one company with people and employees in the same space, you want to think about and be careful with the agreements you're entering into with each other, and make sure that you are not taking on liability that wouldn't be yours to the extent someone gets ill while at the facility. And also ensuring that your other sort of partners in that area, if you will, or the people sharing your space, are also following the various safety measures and protocols. So a lot of times we are seeing now a lot of, in situations like this, where there'll be an addendum done to a contract where each side is representing and warranting, basically mean promising to the other that the employees of each on their site will follow various guidelines, social distancing measures, and so forth. Of course, if you make that representation to another party, again, you have to make sure that you are complying with it, or else you could get into some trouble. So we've seen a lot of that. Another example of this is an indemnification clause. So for example, it's basically you can point the finger at the other person, or the other person can point it back at you should something happen. That's the gist of an indemnification clause, but it's something to look at and think about as we're returning and entering into these types of agreements. Okay, so switching topics again, and this touches on a number of different things, but we're seeing a lot of litigation in this area, not necessarily because of COVID, but just generally. But I do think COVID presents a chance that these litigation and risks will continue. So one thing about this space is you likely have opportunities to collect quite a bit of data about your and information about your customers. It may be on online signups or other data that's collected when they come to the facilities. And that can present a great opportunity. There's a lot of marketing opportunities that come with having customer and consumer data. You may be able to email market, you may engage. There's lots of companies that engage in lead generation that you may be involved with, may or may not, depends. But in that space, anytime you are collecting information for the purpose of then thereafter marketing to that person, you need to be careful, and there's a number of laws that may get you into trouble. And so I'm going to tick off some of them in the next few slides. But the other point that I wanted to mention is in sort of this more virtual world, there's a lot more contact going on by texts or via applications or push notifications. And there's laws around that that basically make sure you have the appropriate consents in place from the customers to be able to communicate with them in those ways. So all of that again though is good. A lot of customers, like that type of contact and continuous communication. But there are some risks, which I want to talk about now. Okay, so email marketing, there's laws in every state. There's also a federal law that limits certain types of email marketing. The gist with emails is you generally, if someone gives you an email, you can send that person an email, including a marketing email. You just can't be deceptive about it. So the gist of that is if you can't have a subject line that says something like, "Hey, it was nice meeting you last Saturday," or something like that. It makes it sound like it's coming from their friend when it's really coming from a business, and now you've sort of snuck in an advertisement for them. So there's laws around that you need to be careful of if you're doing email marketing. Sure, everyone gets marketing messages by email, so you can see for yourself how it's done most of the time, and how sometimes maybe those emails can sort of cross the line into something that might be a problem, basically duping people into opening them. So that's something to watch out for. The biggest one though is if you are sending messages, marketing, check-ins, appointment reminders, any type of text message to your customers, you could potentially be running afoul of what's called the TCPA, which is the Telephone Consumer Protection Act. It is the most litigated statute in sort of the privacy and consumer class action space. It provides for very large statutory damages, so it could be up to $500 or $1,500 per text, which you can see would multiply very quickly. This space is actually quite a bit in flux right now, and the law is still getting clarified, even though the statute's been around for a couple of decades now. So it's another area where we can't give you a clean answer, but it is definitely an area to be careful around and to ensure that you have consent from your customers to send these types of messages. And generally, there's a very specific type of written consent that has to be required, or short code consent. So there may be an invitation, for example, if you want to receive these types of messages, text, yes, or something like that to short code 1, 2, 3, 4, 5. And then there's requirements about the response. The point here is not to lay out all of these requirements, but that if you are engaging in this type of contact with your customers, to make sure to be careful, to check with your legal advisors to ensure that you're doing it correctly. Okay. I touched on this a little bit before, but again, anytime you are gathering information about your customers, there are any number of privacy statutes that kick in. and California just this year enacted a new privacy statute that gives consumers a number of rights that are somewhat new. They're somewhat consistent with the consumer rights in Europe. And now we are seeing a move from other states to enact similar statutes. And frankly, the area is probably going to continue getting more and more confusing because at the time being, each state is enacting its own privacy statutes, some of which have similar requirements, some of which are different. And so now you're talking about navigating different statutory schemes and requirements in each different state. Hopefully the federal government will pass a law at some point that applies everywhere so that it's a bit easier to track all of this. But that's not the case at this time. So really, if you are operating in certain states, you need to be and collecting information about your customers, you need to be aware of what is required for your privacy policy, what you're doing with the information, whether if the customer asks that you delete it, you have to delete it. In what situations can you still withhold the data if they're asking you to delete it, and so on. And then, of course, maintaining any of the personal information and securing it safely. Because another thing we're seeing a lot nowadays are data breaches, which can be very costly, and also, frankly, ransomware attacks, which doesn't really necessarily deal with consumer data, but there's more and more of that in basically every space, almost every day. So those are all things you want to make sure that you are buttoned up on. And frankly, if we're all at home right now might be a good time to make sure our practices are good to go when we finally reopen. I'll just go over really quick. This is some of the issues to think about if you're online and you're trying to ensure that you have consent. Everyone's been online, they've seen these things. The best thing you can do is have a checkbox that people have to check that says, I agree to the terms and conditions, or I agree to contact, whatever it may be that you're getting them to agree to. The key with all of these things, though, even if you're not going to have a checkbox, is to make it as clear as possible that by clicking a button, by continuing, by registering, by signing up, whatever it may be, that person is agreeing to whatever it is you're asking them to agree to. The bigger that language can be, the more obvious it can be, the less cluttered the website can be, or mobile application can be when you are getting that consent, the better and the safer you will be. So I know we wanted to leave time for questions, so I think that's it from me. I already covered the privacy policy. I don't know how. I think folks have to come up close to ask questions if they want.
Yes, that is correct. So yes, thank you. First, a round of applause for our speakers. Thank you very much. One on your keyboard or grip buttons on your clapping hands. And thank you, Jim and Jay and Jonathan. For folks who want to ask Q&A, this is the perfect chance. Actually, I understand not all of us get access to regular access to legal information and advice, and just sort of that perspective on these types of policies. So this is a great opportunity to come up. So come on up if you got a question. I'll go ahead and get things started with a question. I think it's a question for Jay.
Sure.
So in the scenario where I have a location or I'm running an event with VR, and I hear afterwards somebody from there got COVID, or they, I mean, there may be rumors that they think they got COVID there, or they're asking, that sort of information starts coming up, and you start being aware that, oh, maybe one of my customers might have had COVID either before or during or after the event, or at my location. You touched on a few of these different steps and sort of things you should prepare and plan for, but what should I do as a business owner if I get that news?
Sure. So a couple of things I would say. If you, in certain jurisdictions, you may have to report it to to the local sort of health authorities. So that's step number one, figure out whether that needs to happen, and then obviously do it if need be. Most of the local governments and state governments have COVID dedicated web pages that lay all this out. So it should be relatively easy to figure out. So that's number one. The second thing is if you do have a list of everyone that was at the event, which may be the case given the nature of the event, including employees, and there may be other employment issues that I won't touch on, but our advice is generally that you provide notice to those who are at the event to let them know that they may have been in contact with someone who was infected with the virus. Now you have to be careful. You cannot identify that person because that is someone's health information, and you can't be going around and telling people that they have it. But you know, our advice is that you tell folks if you can, as best as you can, as quick as you can.
I got a second question. Actually, yeah, we have somebody with a question. Come on up.
Hi,
David, don't forget to unmute your mic.
Is it working now?
Yes, we can hear you.
Okay. So if like let's say that one of the employees is, you know, at least getting a COVID test because they think they may have been in contact outside of work. Is there any like real obligation to disclose that to anybody like within the actual company right there, or is that really just like kind of outside of, you know,
So
any of the OSHA requirements?
sure. I would say, so they're just going to get a test because they think they may have it, but you don't know yet whether they have it.
Yeah.
Okay. I do not think, as far as having to tell customers that may have been in contact with that person, I don't think that, I think you should wait until you have a positive test. That would be my advice. From an employer standard perspective, my guess is someone, I shouldn't be the one answering this, but my guess is that person should stay home until they know.
Okay.
Yeah, I mean, this is John. I don't know if you can hear me, but from an employment law perspective, if the company is made aware that the employee may have come into contact with someone else that was COVID infected, regardless of whether that person, that is the person who they came into contact with, was an employee also or someone outside, the company does have the right and probably should, if it has reasonable concerns, direct the employee who came into contact with that person to get tested or to take steps to ensure that they will not pose a risk to the workplace or to customers. Ultimately, look, I mean, it's, what if that employee knows about it and just decides not to say anything? There's no criminal liability. There's no civil liability really that anyone could take against that individual. I mean, you really just, we're hoping that people do the right thing, right, when it comes to these types of reporting situations. And once the company is made aware of it, that the company does the right thing within the realm of reasonableness.
Thank you.
Cool. I'm Jeremy again. I had a second question. So Jay also touched on this earlier about tenants and leases. So a lot of the LBE operators that we've been speaking with around the States and around the world as well have been struggling, especially having closed down and trying to work with their landlords to pay for rent. What would you suggest would be what should people do in that case where I have to I'm business is closed, I'm not making any revenue, but my landlord's still asking me for rent. What you touched on it earlier a little bit, but you sort of
Spend more time with it.
yeah, just a little bit, yeah. Like
Okay, sure.
what should the owner do? Yeah.
So there's a number of things. I guess number one is you need to check your lease and read the provisions as close as you can to figure out what rights you have and what the requirements under the lease are. And that can be anything from termination to rent reduction to extending the lease for a period of time where you're, say, I'm not going to pay rent for the following 3 months, but we're going to extend the lease 3 more months. Leases can have many, many, many different types of provisions like that. So number one is to check that. Number two is, and this is not my area of expertise, so I can't tell you, but number two would be, and it's all on our website, Jim mentioned it before, but there are any number of government programs and local programs that may help with this. So loans and sort of tenant protection laws, and I mean, a lot of those apply to, individual homes, but not always and not necessarily. So that's number two, to figure out your options. And then at the end of the day, it's going to be a tough conversation with your landlord. But what we always recommend, if at all possible, is to work out some other type of written agreement. A lot of landlords may not want to do this. They may want to keep the current lease in place and sort of give you promises that they won't do X, Y, or Z, or that they'll be to B, and C. But the best advice I can give you is to get it in writing and sign either a new agreement or some type of amendment. The thing you have to keep in mind is both sides have some pressure, because if a landlord is not getting any rent money, there's no guarantee that the landlord will be able to fill that space if they terminate the lease and throw you out. So don't feel like you are completely lacking in bargaining power. Hard to know though, situation by situation, for sure.
Thank you.
Mhm.
Any other folks with questions? Any other questions? If not, feel free to come chat with our team from Sheppard Mullin anytime. I think they'll be around here, and they also have a booth with more contact information and website information in the expo. But yeah, if not, no more questions. I think we could end a minute early.
Great. Thank you all.
Cool.
Thank you.
you all. Thank you.
Hey, thanks, Jeremy. Thanks, everybody.